All right. Good afternoon and welcome to the National Environmental Law Association's webinar on the role of the Paris Agreement Implementation and Compliance Committee. My name is Leah Hiltonkamp. I'm the Vice President of the WA branch of NELA, and it's my pleasure to welcome you all here today. I would like to acknowledge the traditional owners of the land on which I'm meeting you today, the Whadjuk people of the Noongar Nation. I pay my respects to their elders past, present and emerging. NELA is pleased to host this seminar on an important topic of international environmental law. There will be time for questions at the end, so please put any questions that you may have in the chat function and I will get through as many as possible at the end. As I'm sure many of you are aware, the Paris Agreement is an international treaty that sets out a global framework to avoid dangerous climate change by limiting global warming to well below 2 degrees and preferably to below 1.5 degrees. The Paris Agreement Implementation and Compliance Committee is co-chaired by Hasib Gohar from Pakistan and Dr. Christina Voigt from Norway, who is joining me here today. The Paris Agreement Implementation and Compliance Committee functions in a transparent, non-adversarial and non-punitive manner, paying attention to the respective national capabilities and circumstances of any treaty parties. I will now introduce Dr. Christina Voigt. Dr. Voigt is a renowned expert in international environmental law and a professor at the University of Oslo. She is passionate about legal issues of climate change, environmental multilateralism, and sustainability. Dr. Voigt has published widely on these topics and is a frequent speaker at international and national events. For more than 10 years, she has also worked as a legal advisor and a negotiator for the government of Norway in the UN climate negotiations. She is currently the first co-chair of the Paris Agreement Implementation Compliance Committee. Dr. Voigt is the chair of the Climate Change Specialist Group of the IUCN World Commission on Environmental Law and a member of the IUCN Climate Change Task Force. She is the official candidate for the position of chair of the IUCN World Commission on Environmental Law for election at the IUCN World Conservation Congress in 2021. Please join me in welcoming Dr. Voigt.
Thank you so much, Leah. I assume that was the moment for me to come in. Thank you so much, Leah, for these kind words of introduction. I'm sure you didn't miss out anything. And thank you so much to NELA for, for inviting me today to speak about the topic of compliance and implementation and then the Paris Agreement. As you indicated in your introduction, that's something I have worked on for quite a long time, and I'm accordingly very passionate about it. So I'm happy to speak about it. And I also have to ask you, Leah, to remind me of the time because I can speak about it for a long time. So I'll try to stick to 45 minutes in my presentation. And then I'm very happy to answer any questions or discuss with the audience any issues that may come up. I have a PowerPoint presentation. I'm not a huge fan of PowerPoint, but I think sometimes it can be quite helpful because I want to show you a little bit of the textual bits and pieces for the compliance committee, and might be helpful to use that. Let me try to share my screen. That worked. So what I would like to do is to set the Paris Agreement's Implementation and Compliance Committee, which is a long term, and we have started using the abbreviation PIKE, Paris Agreement Implementation and Compliance Committee, to set it in the context of how accountability is structured under the Paris Agreement, accountability of parties for their performance. And what I'd like to do is to explain a little bit what I mean with accountability, and then start setting the compliance committee, as I said, in the general framework of the Paris Agreement, because you can't really only look at it in an isolated manner. It's important to see how it fits in the overall architecture of the agreement, which, as Leah just explained, and as I guess everyone knows, is supposed to enhance the global response to the threat of climate change by doing a number of different things, which I will explain in due course. So I'll say a little bit about which accountability elements there are under the Paris Agreement, in particular when it comes to the communication of national determined contributions, the NDCs. And that is then continuing into the in the transparency framework, the enhanced transparency framework, or ETF. And I will address these two issues very briefly before I then spend most time on that third aspect of accountability, on implementation and compliance in the context of the committee. And then finally, and that should lead over to maybe some more discussion, what are the expectations in the context of compliance and accountability for COP26 it is, I'm sorry, not COP25, COP26 in Glasgow, in CMA3, I'm sorry, in Glasgow in November this year. So let me just, as a background information, it's not really to promote myself, but if you are interested in the issue of compliance and how it fits into the overall structure of the Paris Agreement, I did co-author an article together with a Chinese author, Gao Qiang, and it was published 2 years ago on the interplay between transparency and compliance. And I mention that because we wrote it because Gao Qiang, he was the co-facilitator for the negotiations of the transparency framework all the way from Paris to Katowice. So he facilitated those negotiations that then ended up with the adoption of the Katowice rulebook and the decision on transparency. So he's seen everything in the whole discussion on the transparency framework. And I, on my side, I was the co-facilitator for the rules for the compliance committee. So I've seen, how parties approach compliance for a long time. And we thought it might be helpful if we put our heads together and write this piece. And so if you're interested, you see the reference on this slide, and I can also send it to Leah if you're interested. So accountability, the reason why I put this talk in the context of accountability is that, yes, the Paris Agreement is often hailed as an important agreement, which it undoubtedly is, but you often hear that it's very weak and leaves a lot of space to parties, and sometimes you even hear it's not legally binding, which is something that I always push back. As Leah said, of course, it's a legally binding international treaty, but it does set up a quite a sophisticated accountability structure. It is not entirely straightforward what parties' legal obligations are and how they're being picked up in the under the agreement itself, but it does have several accountability elements. Before I dive deeper into this, what I understand as accountability in this context here is just simply the answerability of parties for their action, answerability either to a particular body or to the public in general, in terms that they have to be transparent, they have to explain themselves, provide information and data to show how well they're doing. And here in the context of the Paris Agreement, of course, it's the answerability of parties for aspects of their performance in accordance with the rules, with the provisions set up under the agreement and the mechanisms and procedures established thereunder. And what we see is that there are different degrees of accountability. For some aspect of the agreement, there is very weak accountability. There is nothing that really checks on how parties are doing. And for other aspects, there is stronger or even strongest accountability. And I'll try to briefly run you through this traffic light system that I tried to set up. In a way, there is an accountability continuum from the submission of NDCs all the way through the compliance element in the very end. this is the continuum that I'd like to introduce to you. Parties have to submit a nationally determined contribution under Article 4, paragraph 2 of the agreement, and they have to submit it every 5 years under Article 4, paragraph A. And that nationally determined contribution communication or submission, that is a legally binding obligation. That is something that parties have to do. It says each party shall. However, what parties put in their NDC, the content, the numbers or the measures or whatever they put in their NDC, that is not legally binding. They're not bound to the substance of the NDC, but it's a procedural obligation to put forward an NDC. But once they have done so, they kind of enter this compliance accountability continuum, because each party is then also required to communicate or submit what is called a biannual transparency report under the transparency framework, which was set up under Article 13 of the agreement. So every 2 years, but starting in 2024, so we haven't seen any of these reports yet, parties have to provide information on how well they're doing in progressing with the implementation and achievement their NDC. And then finally, we have that red light element of accountability, which of course is the compliance and implementation committee, because that committee is designed or was designed and set up to pick up situations where parties do not comply with their legally binding obligations. And I'll come back to what these legally binding obligations are in a couple of minutes, but this is the strongest element of accountability we have. It's not super strong, I'll explain that, but at least in terms of the different accountability elements under the Paris Agreement, this is the strongest, or as strong as it could get when the agreement was negotiated and adopted in Paris. And as Leah said, I had the privilege of being a legal advisor and negotiator for Norway, and was involved exactly in the negotiations of the agreement, and in particular of the compliance mechanism in the committee. Accountability is important in the context of transparency, but then also of compliance, because, well, just focusing on transparency first, transparency as an element of accountability is important because not only does it provide clarity to each and everyone on what parties actually do put into their nationally determined contribution. As I said, it is not, the content is not legally binding, therefore transparency is much more important. But it is also important to know what they put into their NDC in order to understand how well they're doing in terms of reaching the collective temperature goals of the agreement, and also for tracking progress under the transparency framework. But transparency in general is incredibly important because it is the element meant to build trust and mutual confidence that parties actually put forward ambitious NDCs, ambitious targets in their NDC. If we wouldn't have transparency, we wouldn't know what parties are actually doing. But the accessibility of this information is also crucial for the, how can I say, the dynamic elements of the agreement to push up ambition, because it is something that enables peer pressure. Parties look at each other's NDCs, and it enables public or bottom-up pressure from the public and stakeholders, because they have access to this information and can be critical or praise or whatever they do, different parties. Now, in this continuum, then compliance is important because, first of all, it is crucial for the functioning of the Paris Agreement as such that there is a compliance element. It wasn't easy to get a compliance committee or compliance mechanism established in the Paris Agreement. There was an incredible amount of pushback and concern by many parties when the idea of a compliance committee first came up. And it came up fairly late in the negotiations, about a year prior to the adoption of the Paris Agreement was when the idea of compliance entered the Paris Agreement's negotiations. And what some parties feared was that if we include a compliance committee, then that may lead to weakening all the other obligations, because parties would then say, oh, we don't agree to, or we don't commit to very ambitious obligations, because we would then be afraid that there's a compliance committee that picks up on that. So it was a very delicate balance to be made between having strong obligations throughout the agreement, but also having the possibility of an independent body that can then check on how well parties are doing. It was, as I said, it was incredibly difficult and sensitive, but by the end of the day, it was something that was agreed in Article 15 of the Paris Agreement. I think the one argument that in the end helped us to secure that there's a compliance committee was we asked parties, or those parties that were reluctant, you know, if the Paris Agreement is adopted and the world, and you go home and you start celebrating and you get the question, so what happens if the main legal obligations are not complied with? And there is nothing you can say. There is nothing, nobody that picks up on non-compliance. How would that look? And I think that was an argument by the end of the day that convinced those parties that were skeptical to agree on a compliance committee. But as Leah also said, it is a compromise solution, as everything else in the Paris Agreement. It is facilitative in nature. It is based on helping parties rather than punishing them for non-compliance. But I'll come back to that towards the end of my presentation. And again, that was part of the general negotiation setting that concerned some parties that may not even join the agreement if the compliance measures would be too strong. So it was a very delicate balance between participation, inclusiveness, and the strength of the legal obligations in the agreement themselves. But in the end, it was included, and it's meant to enhance trust and confidence that parties actually do what they said they would do. And if not, then they would be held accountable for non-performance. Very, very briefly on the NDCs, and I don't want to go deep into that, and I assume that you all know well about what nationally determined contributions are, and I already mentioned it, but they are written down. The obligation is written down in Article 4.2, and I show this here because it links to the compliance committee. According to Article 4, paragraph 2, each party shall prepare, communicate, and maintain successive nationally determined contributions. And then you see what I highlighted in red. This is how it phrased in the agreement, where it says that it intends to achieve. So the achievement of the NDC is not part of the legally binding obligations, is only an intentional aspect connected to the NDC. Importantly, also, each NDC or each party's successive NDC will represent a progression beyond the current NDC. And we see now the discussion around enhancing and updating of NDC, and I'll again come back to that later on, and that each NDC reflects the party's highest possible ambition. This is both parameters that are written down in Article 4, paragraph 3. Now, in addition to communicating the NDC, parties also have an obligation when they put forward their NDC to provide information that is necessary for the clarity, transparency, and understanding of the NDC. So it's not just that you can submit some sort of document, but it has to be structured and designed in a way that is actually clear and transparent and understandable for everyone else. And that is also a legally binding obligation, which is written down in Article 4, paragraph 8, which says each party shall provide information. Now, when it comes to the NDCs, and that is what I mentioned or meant with a weak accountability element of the Paris Agreement, when it comes to the NDC, the only check we have, and that is the compliance committee, is whether a party has or has not communicated an NDC. There is no system under the Paris Agreement that actually checks whether the NDC is progressing compared to the previous one, or is at the level of highest possible ambition. There is no mechanism or function under the Paris Agreement either that checks on whether this information is provided to enhance clarity, transparency, or understanding. This is something that is not fortunate. I think it's partly an oversight, partly a political decision that nothing in the Paris Agreement actually picks up on the content of the NDC and whether that information is there or not. The only aspect that we have is the transparency framework, but this is only dealing with the implementation and achievement of the NDC, not with the NDC itself. But as I said, once a party has submitted an NDC or communicated, then each other year thereafter, starting in 2024, the party has to submit or provide a biannual transparency report. And that report has some elements that have to be there, legally binding obligations. The biannual transparency report has to include a national greenhouse gas inventory report, and it has to include information to track progress in achieving and implementing the NDC. For developed country parties, the report also has to include information on the support provided to developing countries, and that's financial support, but also capacity and technology transfer. In addition, there are some elements that parties voluntarily can put into their biannual transparency report. You see them on the bottom of the page, like adaptation measures or support that is provided by developing countries to other developing countries, for example, in the South setting, but these do not have to be there, and it's just something that parties can choose for themselves. Now, every biannual transparency report, which is supposed to be coming from each party every other year, but every single biannual transparency report is then supposed to go through a technical expert review. There will be teams of technical experts that review every single report. So it's an incredible amount of work ahead of under the Paris Agreement, and quite a challenging logistics around this. But that technical expert review will look at whether the information provided by parties is consistent with the guidance on providing information, which was adopted as part of the Katowice rulebook in 2018. And then the technical expert review teams will submit a technical expert review report where they actually say, well, party X has complied with its reporting obligations or not. And then the technical expert review report can point out areas of improvement, where they can give some recommendations or encouragements. And that depends on whether it's a shall obligation that was not complied with by the party, or it's a non-shall provision. It gets a little bit technical, but it's important in order to understand what the compliance committee is supposed to do. And then by the end of that process, under the transparency framework, also each party has to participate in what is called a facilitative multilateral consideration of progress, which is also set up under Article 13, which is basically, it's a two-tier process, but each party is supposed to be accessible to every other party and to stakeholders to stand and answer questions with regard to its implementation and progress of its NDC. So the transparency framework is, you can imagine it as this line of different processes, where it starts with the submission of the biannual transparency report, the BTR, that goes then through the technical expert review. Then the technical expert review also produces a report on how well the party did in reporting, and that goes then all through the facilitative multilateral consideration of progress, the FMCP. Okay, so the transparency regime is designed in a way to pick up on parties' performance under the reporting requirements. It is stronger than what we have when it only comes to the communication of NDCs, but it ends with just recommendations or encouragements by the technical expert reviews teams. So it is stronger or medium strong, but it has no means of actually telling parties what to do or pick up on if a party does not comply with these recommendations or encouragements. And this is, of course, where the compliance committee comes in, or the compliance mechanism, which is supposed to consist of a committee. So this is how it is designed under Article 15 in the Paris Agreement itself. And I just copied and pasted Article 15 for your information so that you can see that the mechanism to facilitate implementation of and promote compliance with the provisions of the Paris Agreement was established in the agreement itself. Which is quite important to know, because it is part and parcel of the institutional framework of the agreement. It wasn't in hindsight developed or established by a CMA decision. It is in the agreement itself. As you see in paragraph, I'm sorry, in paragraph 1. Paragraph 2 sets out that it is supposed to be expert-based. That means that the members of the committee work in their individual expert capacity. They're not supposed to represent their parties or countries. I have to admit that this doesn't quite seem to be the case, because everyone in that committee is pretty much speaking on behalf of their party. But the way it was envisaged is that the members of the committee are experts in their field and not party representatives. I'll come back to that. It is facilitative in nature and is supposed to function in a manner that's transparent, non-adversarial, and non-punitive. And again, these elements had to come in as part of the overall compromise on including a compliance element in Paris Agreement. There had to be assurances that it cannot be punitive, because if it had been punitive, I think we would never had any compliance mechanism or committee in the agreement. Then the pushback by many parties would have been too strong. And the question is, what is better? A compliance mechanism that can take certain measures, but doesn't have the strongest teeth that you can imagine, or none at all. And that were the two basic choices we had in Paris when we negotiated this. It also is, I already mentioned these elements, it is also requested not to duplicate any efforts that are being made under other elements and mechanisms under the Paris Agreement. And it's partly the reason why I showed you the transparency framework, because the compliance committee has to be very careful not to do and not to overlap with what the transparency framework does, especially what the technical expert review does, but link on to the outcome of the technical expert review. And it's also very clearly written into the modalities and procedures for the compliance committee, which were adopted as part of the Katowice rulebook in 2018, that it is shall not function as an enforcement or dispute settlement system. That is not the role of the compliance committee, and it shall not impose sanctions or penalties, and again, respect national sovereignty. So this is, again, something that guides the work of the committee, and it is something that parties were very clear and strict about. The membership of the committee is diverse. The membership, the composition of the committee was already decided in Paris in the accompanying decision that adopted the Paris Agreement, Decision 1 CP21, which set out that the committee shall have 12 members, 2 members from each of the UN regions, so 2 from the African group, 2 from the Asian Pacific group, 2 from the Eastern European group, 2 from Latin America, and 2 from WEOC, that's the Western European and Others group, where Australia is part under Others. And then 1 member each from small island developing states, and 1 member from least developing countries. So these are the 12 members which are supposed to compose the committee. In addition, there are considerations of gender balance that the committee, or the CMA, which is the body that nominates the members or adopts the members. So gender balance is important, and the committee members are elected for a course or term of 3 years each, and then they can be re-elected once. Now, in Katowice, when the modalities and procedures for the committee were adopted, the 12 members of the committee were accompanied with 12 alternate members. That was a bit of a surprise. I didn't quite see this coming. But we have now 24 members that together constitute the committee, 12 members and 12 alternate members. The first members were elected in Madrid in 2019, and the committee met for the first time only about a year ago in June 2020 for the first time. And since that meeting in last June, the two co-chairs, Kasib Gohar from Pakistan and myself, were elected as the co-chairs. And since then, we have been meeting 5 times virtually online. The committee itself has never met in person due to the current pandemic. Now, we are currently in the middle of the 5th meeting, and we meet every day this week, which is quite an interesting setup, because I'm happy to speak about the work what we're doing at the very end. This is the overview of the current composition of the committee. You see here under the Western European and others group, this is where I'm the member, and my alternate member actually is an Australian, Julia Gardiner, who is the Australian member of the committee. And you see that there are a couple of seats which are still vacant, in particular in Latin America, who have not been able to nominate their members or alternate members. What can the committee do? Well, firstly, there are 3 ways of how an issue can come to the committee. First of all, any party at any time can by itself go to the committee with an issue of implementation or compliance. So that the possibility of self-referral by a party to say, hey, committee, we have a challenge with, let's say, our adaptation communication or the next round of our NDC. We need support, we need help, we need that you help us facilitate how we implement and comply with the Paris Agreement. The likelihood of a party coming to the committee by itself is probably very limited. There is not a huge track record of parties actually going to a compliance committee on their own, but the possibility is there. The second element is a list of legal obligations, if not complied with, will trigger the automatic initiation of an issue by the committee. And I show you which obligations there are in my next slide. And then the third way of the committee becoming active is exactly the link to the transparency framework. If the technical expert reports indicate that there are significant and persistent inconsistencies of how a party reports on implementing and achieving its NDC, then the committee, with the consent of the party, can or may take up this issue. This is how it links back to the transparency framework, and that's also the reason why I briefly went into the transparency framework. Plus, fourth, the committee also has a systemic function. If in the course of its work, the committee sees that several parties seem to have the same challenge, for example, they are not able to meet a certain deadline, or they're missing certain information in one of their reports, that may indicate that this is not an individual case of non-compliance, but perhaps there's something more systemic behind it, that the rules are not quite clear, or it's just not possible to meet this deadline or something like this. And in that case, the committee can make a recommendation to the CMA, to the Conference of the Parties, serving as the meeting of the parties, the governing body of the Paris Agreement, and bring this to the attention of the CMA and say, hey, parties in general, CMA, here is an issue that needs your attention, that needs to be rectified because it is a systemic challenge for many parties. So briefly to the self-referral, just very briefly to the 3 or 4 elements of how the committee can get active. This is how self-referral is identified in the rules, in the modalities and procedure adopted in Katowice, where it says that the committee shall consider issues related to implementation and compliance based on a written submission from a party with respect to its own implementation and compliance. So that is always possible, but as I said, we still have to see if any party ever is going to avail itself of this opportunity. This list is what I call the automatic initiation of the committee, where it says that the committee will initiate the consideration of issues in those 4 cases. There, the committee does not have discretion. It will get active. And these 4 elements are the core legally binding obligations that parties have under the Paris Agreement. So you see in litera A or Roman A, in the case where a party has not communicated or maintained an NDC in accordance with Article 4 of the Paris Agreement, and it's not in the registry, the public registry, in that case where a party does not have an NDC, the committee will initiate consideration of this issue. The second, Roman 2, is a situation where a party has not submitted a mandatory report or communication of information under Article 13. And that links to the biannual transparency report. So if a party has not submitted a biannual transparency report under the transparency framework, then the committee will get active. Now, it doesn't say biannual transparency report in Roman 2 here. And the reason is that the term biannual transparency report does not appear anywhere in the Paris Agreement. It's something that was then only included in the Katowice rulebook. But when we negotiated the modalities and procedures for the compliance committee, that term biannual transparency report wasn't yet coined. So what is important is that all the different elements of mandatory information that I showed you that need to go into the biannual transparency report, each one of these mandatory informations has to be in place. And if one element is missing, then the committee will become active. For example, if there is not a greenhouse gas inventory report, but otherwise the biannual transparency report is there, then this would, for example, be an issue for the committee to become active. Roman 3, the case where a party has not participated in the facilitative multilateral consideration of progress. You remember that transparency line that I showed you, which ends with the participation at the FMCP, the facilitative multilateral consideration of progress. If a party doesn't show up, if a party says, oh no, we're not doing that, this would be an issue for the compliance committee. And finally, the situation where a developed country party has not communicated a mandatory finance information under Article 9, paragraph 5. This is information on projected levels of finance for developing countries, and this information does not go through the transparency framework. It's an independent channel of communication, but if a developed country party does not provide that information, which is a legally binding obligation to put forward this information, that again is an issue for the compliance committee. There's an important caveat. So if any of these elements are missing, or a party has not complied with its legal obligations to provide reports or an NDC, that would trigger the compliance committee to become active. But the committee will only look at whether that report was submitted or not, like a binary yes or no, 1-0 kind of distinction. But the committee will not look into the content of an NDC or report or the communication. It is not concerned with the substance of what was communicated. It is only concerned with the procedural obligation to submit a report or not. I just hop over that. And finally, the systemic function. Oh no, let me go back. The third aspect of initiation, as I said, that links directly to the transparency framework, is where a party, where the technical expert review team, has identified significant and persistent inconsistencies in the reporting of a party, and then could the committee that in that case it has discretion with the consent of the party, so it has to ask the party pick up on this issue. This is arguably a very weak link, but it's something that was meant to provide a backstop to the technical expert review, which basically ends with just giving a recommendation or encouragement, but they can't do anything thereafter. But at least here, the compliance committee has the possibility, if the party agrees, to help the party to get back into compliance. Significant and persistent inconsistencies is something that the committee currently tries to get its head around of what this actually means. Persistence, for example, means that it has to happen in several transparency reports. So at least, for 1 or 2 reports, the transparency experts, technical experts, would have had to point out particular inconsistency. So we're looking at a long-term non-compliance of a party before the committee could get active under that particular trigger. And the systemic function that I already mentioned is that the committee can, if it identifies a systemic issue, bring those to the attention of the CMA. The CMA can also request the committee to look at systemic issues. That is a pretty much unexplored function of the committee yet, and we're working on what this actually means as we speak. Now, finally, what can the committee do? What is actually the possibility of the committee to react to cases of identified non-compliance? And here the committee is required to take appropriate measures. It shall take appropriate measures, which have to be identified, of course, on a case-by-case basis. And then it has a whole toolbox of different measures that it can apply. First of all, it of course has to engage in a dialogue with the party concerned and has to say, hey, party X, what is the situation? Why is there no NDC, for example, to identify what exactly are the challenges and what solutions could be recommended. It is understood that in many cases, non-compliance may be based on missing support. There may be no capacity, or there may be technology missing, or finance. And so the committee can get in touch with the party concerned and engage in the party's outreach to the support mechanisms under the Paris Agreement. It could be the Green Climate Fund, or the Paris Committee on Capacity Building, or the Adaptation Committee, or whatever it is. So the committee can help that a party gets in a contact with these support arrangements. The third element is that the committee can recommend the development of an action plan. It can ask the party concerned to provide a plan of how it itself sees how to get back into compliance, what the timetable would be, what the needs are, and what measures it would adopt in order to get back into compliance. And the committee can then request on a current continuous update on how well this action plan is being implemented. And the most, the most stringent measure that the committee can adopt, the one with maybe half a tooth to it, is that it can issue a public finding of fact. In cases of non-compliance, maybe the last resort measure that the committee can adopt is that it can issue a public statement that country X, party X is based on those facts, not in compliance. You may say this is perhaps fairly weak, and if you come from national legal system, that perhaps sounds fairly weak, that the only thing that committee can say is your party X is not in compliance. But in international law, international relations, to be called out by a committee in public in front of the entire world, basically, with a statement of non-compliance, is a very painful measure, and only the engagement, for example, with the compliance committee has already caused under the Kyoto Protocol Canada to withdraw from the Kyoto Protocol. So that was only based on the first letter from a committee, let alone, you know, a statement, public statement of non-compliance. Parties, states are they are proud and they don't want their reputation to be tarnished by any statement or finding of fact. So if the committee ever gets so far to issue a public statement of non-compliance, it is actually quite a stringent measure, and maybe even punitive to a certain extent, you can say, even though the committee is not meant to be of punitive character, but it has this possibility as a last resort. Leah, can you indicate how much time I've have still?
I've left 10 minutes for questions at the end, so there's 4 more minutes.
Okay, good, that's good, because I'm almost at the end, but I have a slide which I wanted to show, which I try to explain how this all works in a more dynamic fashion. So you see on top, you see party, and down you have the Article 15 or the compliance committee. And now what I'm trying to show is how different issues actually get to the committee based on what I basically just said. So the first example that I pointed out is that the developed country here has the obligation to communicate finance obligation under Article 9.5. If it did so, that's fine. If it did not communicate that communication, this issue goes directly to the compliance committee. It will take up this issue of a developed countries not communicating that finance information. The second situation was where a party, what the obligation is the communication or maintenance of an NDC. If a party has no NDC in the registry, this is an issue which goes directly to the compliance committee. If the party has communicated an NDC, then the party, of course, the compliance committee will not get active immediately. But if there is an NDC, then this means that the party enters also the transparency regime. It has to provide or submit this biennial transparency report every other year, starting in 2024. And the transparency report, as I said, has to have these mandatory pieces of information: the national inventory report, the information on implementation and progress of the NDC, and for developed countries also finance information. If the biannual transparency report as a report in general is missing, or if any of these mandatory pieces of information are missing, this goes to the compliance committee. If the biannual transparency report is there with all the pieces of mandatory information, then this goes to the technical expert review, the TER, which then issues a technical expert review report, the TERR. And if that report points out that there are significant and persistent inconsistencies in their recommendations and the party consents to it, then this issue may be picked up by the compliance committee as well. And finally, where does it work here? I have to move this around. Finally, the parties are required to participate in the facilitative multilateral consideration of progress. If a party does, I'm sorry, there's always this line of pictures in the way here. Okay. If a party does not participate, then it goes to the committee. If the party participates, then that's fine. And then then there are different measures that can be complied, and the entire black box that I indicated here, that's the transparency framework, and everything around is how the committee works inside and outside the transparency framework. As you can see, there's quite an intricate interlinkage between the transparency elements of the agreement and how compliance and the compliance committee's role and function link back to the transparency framework, but also has certain functions and roles outside of it. So just to wrap up, this is how the committee is supposed to function under or within the framework of the Paris Agreement and the architecture of the framework agreement, of the Paris Agreement. Now, what also happened, I just wanted to point this out to you, is that you know that currently there are negotiations ongoing on carbon markets or cooperative approaches under Article 6 of the Paris Agreement. There are Article 6.2 are bilateral transfers of ITMOs, that the internationally transferable mitigation outcomes, that's the units that can be traded between different parties, or Article 6.4, which sets up a carbon crediting mechanism. And these rules are not in place yet, and hopefully they may come into place in Glasgow. But in the meantime, a number of parties have started to start carbon trading based on bilateral agreements. In particular, Switzerland has been quite active and has entered into agreements with Peru, with Ghana, and with Senegal so far. And in those bilateral agreements, carbon trading agreements between Switzerland and those three countries, you find this particular provision in all three of these agreements, where there is a possibility to suspend the transfer of carbon rights between the two countries of that bilateral contract in the cases of non-compliance with Article 4, paragraph 2, that's the communication and maintenance of an NDC. And here it says that this consideration of compliance should be based on the consideration by the compliance committee. So what this means that is, if the compliance committee finds that, for example, Switzerland or Peru or Ghana or Senegal does not have an NDC and finds that is therefore in non-compliance with the Paris Agreement, the two parties to these bilateral contracts can then suspend the recognition of these mutual transfer of carbon trading credits. This is an interesting legal consequence that we were considering when we were negotiating the compliance committee's measures, but it was impossible to include it in that list of measures. But it is very interesting to see now that parties themselves in their bilateral or even multilateral legal agreements on carbon trading include the possibility that if the committee says party X is non-compliance, that this may have, or this has the consequence of the suspension of a party's rights to participate in carbon trading in that bilateral session. So I thought that was quite interesting. So what's the current work? What's the committee doing? For example, this week, we meet every day for 3 hours online, as I said, which is quite challenging. But we are developing our rules of procedure. As I said, the committee was established in the Paris Agreement, Article 15. It has a set of modalities and procedures that were adopted as part of the Katowice rulebook in 2018, in decision 20 CMA1. But there are some aspects missing, some technical aspects missing, for example, on timelines, on confidentiality, on observer participation, and a couple of other things. And that's what we currently work on these rules of procedure. And it's not easy because the committee itself has only worked virtually. We've never, ever met in person. I do know quite a lot of the committee members from the negotiations, but there are also committee members who come from different parts, have different backgrounds, and we have never met in person. And working virtually is really, really difficult because in order to agree on something, you need to establish trust. You need to be able to, have confidence in the other members, and that is very, very difficult to establish in a virtual setting. But I hope we're getting there. At the end of next week, that we can actually adopt our rules of procedure, or not adopt, but we have to submit them to the CMA to be adopted by the CMA in Glasgow. And the question is, when will the committee actually kick in and become active? Because there are a number of parties who do not have an NDC. Well, we have to adopt these rules of procedure, hopefully in Glasgow, and then early next year, we would be ready to go. So what are the expectations? That's my final slide for the COP, the CMA in Glasgow. Well, hopefully the rules of procedure will be adopted based on the recommendation that we are currently working on. But in addition to that, of course, you know, there are many other things that are supposed to happen in Glasgow, not only the completion of the rule book on several aspects that are still missing, for example, common timeframes for NDCs, but also common reporting tables for the biennial transparency reports, which is quite important then again for the compliance committee of how that reporting actually looks like. But also the outline for the technical expert review report. Again, also very important for the committee because it needs to link up to the technical expert review report, but the outline for the report still has to be adopted in Glasgow. And then Article 6, that is the article on carbon trading on cooperative approaches, which, as you perhaps know, is an outstanding issue where parties have not been able to agree on in Katowice and neither in Madrid, but hopefully in Glasgow. But in addition to that, parties also, developed country parties, have started to communicate their Article 9.5 finance communication. That's the ex-ante finance communication of how much money parties actually will provide to developing countries. It's a very interesting obligation, and there's a particular website under the UNFCCC website where you can see these communications coming forward. But again, there's some missing, and as you know, as I told you, this is a legally binding obligation, and if that communication is missing, that is something that the committee would have to pick up on. But at the overall, not necessarily at the level of negotiations, the COP in Glasgow is also, of course, much about ambition, raising ambition to the level that is necessary. As you know, there's a request for parties to update or enhance their NDC. Many parties have done so, and the expectation, of course, is there that parties, further parties do so then at the COP. In particular, maybe also motivated and encouraged by the current or latest IPCC report AR6 that was just published a couple of days ago, and I'm sure you picked up on that. And with its dire warning of the consequences, if not drastic, rapid measures to mitigate climate change are taken. So I think the COP will be pretty much in the light of this IPCC report, and hopefully that enhances also the willingness of parties to update and or enhance their NDC. That is all from my side, and I'm happy to answer any questions.
Well, thank you very much for that. I certainly learned a lot. And as you kind of said at the outset, quite a common question, I would say, is, well, what can we actually do if a country doesn't meet its goals or targets under the Paris Agreement? So that certainly helped me understand that compliance framework a whole lot more. I see we've got one question, which is actually from the national president of NELA, Hannah Girath. It's actually more of a statement, but quite an interesting one. She says, "Thank you, Professor Voigt, an excellent presentation. Attendees, and you may be interested to hear that in February of this year, NELA recommended to the Australian Parliament's joint regional, to the Australian Parliament's Joint Committee of Public Accounts and Audit that Rule 17AG3 of the Public Governance Performance and Accountability Rule made under the Public Governance Performance and Accountability Act should be amended to include reference to the external scrutiny reviews and decisions applied by international governmental organisations, including United Nations agencies, regional organisations and convention bodies, so as to enhance the Australian government's transparency and accountability. The inquiry has not yet reported, but it could be in an important way for our Parliament to scrutinise the Paris Agreement biennial transparency reports, as inquiries can be initiated in relation to the annual report matters." So I've also just had another question from Alexandra Valero. She says, "Hi, Professor Voigt. Thank you so much for your insight into the compliance with the Paris Agreement. I wanted to hear your opinion on whether the ICJ, so the International Court of Justice, I assume, could play a role in addressing climate change for better compliance with the agreement. Do you think maybe an advisory opinion would help with COP negotiations, NDC setting and compliance amongst parties?
Yeah. I just thought there was also a question on human rights, and it would be good to come back to that in a second. Well, first of all, to Hannah Hajareth comment, which I found really interesting on scrutiny and providing information also coming from international bodies and arrangements. I think that is an excellent proposal and absolutely important. Of course, the information is available and it's publicly, it's online available on UNFCCC website, but the public in general probably doesn't go, all the time to the UNFCCC website and checks on that information. So having a possibility that the national government actually is responsible for bringing that information in, for allowing the public to scrutinize it and also react to it, and stands accountable for information, also for its performance, is very, very important. And as I said, the biannual transparency report, once they come, will be very detailed, and they will contain information on how well parties are implementing and progressing or achieving their NDC. And that's going to be very, very important information for the public to pick up, and also to exert pressure on increasing, hopefully, the level of ambition and also the level of implementation and achievement for each single party. So that was very interesting to see, and congratulations to NELA for making this proposal. The second question on the role of the ICJ, that's a very good one, and a very pertinent one, apparently, in this current wave of climate litigation worldwide, which is basically on a national level. But of course, we have the first cases on regional courts, in particular here in Europe, with the European Court on Human Rights that looks at climate change issues. But the ICJ has not yet been asked or has any contentious case with regard to climate change. But it doesn't mean that it may not come. Well, the fact that there is an in-house compliance mechanism like the Paris Agreement Implementation and Compliance Committee does not prevent any party to take an issue or dispute to the ICJ. It does not prevent that. It is just an in-house possibility to address issues of non-compliance, but it is absolutely possible to, for example, take a party to the ICJ for non-compliance with its obligation under the Paris Agreement, or to request an advisory opinion, if I understood the question correctly. And there are currently certain initiatives underway to explore the possibility for an advisory opinion by the ICJ with regard to climate change, but maybe more with regard to clarifying the content of the customary rule of prohibition of transboundary harm and what that rule actually says or means in the context of climate change, not so much in the context of the Paris Agreement, but I would assume that that customary rule would then also be, seen in the light of the Paris Agreements, especially its goals. Whether that would help the negotiations, that is something I doubt. I think the resort to the ICJ, the International Court of Justice, may not be very helpful in pushing forward ambitious outcomes in the negotiations. It's very different settings, very different systems, the political dynamics and diplomatic dynamics of the negotiations, as opposed to an advisory opinion or a contentious case at the ICJ. Some fear that it may actually be counterproductive if the ICJ was involved. But at the same time, coming back to the IPCC AR6, we just don't have any time anymore. This is very clear that the IPCC was clear that basically every ton of CO2 emitted is 1 ton too much. And that if we want to stand a chance to keep warming somewhere close to 1.5 degrees, then pretty much every emission and every degree of warming has to stop. And that has not yet translated into action and into political willingness. And maybe the last resort will be the courts, as we've seen already in many cases worldwide. Whether that will be an international court, I'm not so sure, but national courts worldwide are, as you know, being in the picture, and very rightly and very importantly so.
All right, it is more than half past. It's up to you. I'm actually getting quite a few questions through now. Perhaps we can do one more. I know you said you wanted to go back to the human rights one, and then we will wrap up. So I will just quickly read that. That is, will the Paris Agreement Compliance Committee be provided with comments and decisions under human rights conventions? For example, there has been a recent communication from Torres Strait Islanders here in Australia about the impact of climate change and Australia's poor performance on sea level rise and their futures.
No. Is no. I'm very much aware of the case, but that is something that the compliance committee is not involved with, or in any case will provide comments or decisions. That's a very different setting again, and what I tried to say is that the moving space or the operating space for the compliance committee is fairly limited. It is defined by the modalities and procedures and by the rule of procedures, and it can only operate within that space. So it will not engage in human rights litigation. But I think most of the committee members are lawyers, not all of them. They have to have a broad background. And they're very critically watching what's going on, and we do have discussions within the committee, but just informal discussions of the members. But the committee has no role with regard to human rights violations. But if a country would come to the committee and ask for support or help or advice or whatever it may feel in relation to how it best could address the issue of protecting human rights, then the committee were to think about it. But that would only be in the context of self-referral by a party to the committee. But it is not unthinkable. It is possible that a party may actually do come to the committee and say, hey, we have challenges with our adaptation plan, or we want to include human rights issues. We don't know how to do it. We don't know which institutions to set up, or whatever the question may be. And then the committee would be faced with that issue of how to deal with human rights. And by the way, Leah, I do have a couple of minutes left. It's just up to you and the audience how long they want to stick around.
Okay, I was going to say there's another very interesting question from Alex Gardner, who actually taught me environmental law over here in Western Australia. So interesting, because you taught me in Norway. So he has asked, why did the Article 20 provision of or regarding carbon market suspension not apply to failure to submit a biannual transparency report as well as the NDC? Keeping up to date on emissions information could be crucial to the functioning of the transnational carbon market.
Yeah, that's a good one. I mean, this Article 20, I hope that was clear. That was an Article 20 from the agreement between Switzerland and Peru. So the biannual agreement between Switzerland and Peru on Article 6 exchanges contains that provision. And I wasn't involved in those negotiations between Switzerland and Peru, and why they only included the non-communication or non-maintenance of an NDC as the only reason for suspending the right for carbon transfer. I completely agree with Alex that it would make equal sense to also have that extended to the biannual transparency report. If that is missing or information is missing, that could be an equal reason or equally important reason to suspend the transfer of carbon credits. But it's beyond my knowledge why Switzerland and Peru only limited to to NDC issues. Maybe you should send this question to to Switzerland and Peru and Ghana and Senegal.
All right. Well, thank you very much for your presentation today. It's it was very, very insightful, and I think the questions were also really good. I definitely learned a lot, and perhaps if you don't mind, if we are able to share your slides with those people who registered, let me know if that's okay or not. But I could send them out to everyone by email afterwards. So thank you very much for giving up your time and sharing your knowledge with us. It's much appreciated. So thank you on behalf of NELA, National, and everyone who attended.
Thank you so much. Thank you. Thank you, NELA. But also thanks to the audience that you stayed with me, but also for these very excellent questions. It's a pleasure to be able to engage, even in this virtual format, or because of that virtual format, with such an audience far away. And I'm happy, Leah, to send the slides to you, and you can disseminate them within the network.
Great. Thanks very much. All right.
Thanks,
Take care.
everyone.
See you. Bye-bye.
Well, bye-bye.